Okay, but again, I mean, I think that's a powerful argument. The question is whether it's a constitutionally compelling one. If the University of California, for example, created an affirmative action program 10 years ago because there weren't enough women professors or African American professors, and then this year it decided to change the policy and it eliminated the affirmative action program, and African American and women petitioners came to this court and said it's too early to eliminate the affirmative action program. The program still is necessary to create equality. Could you argue to this court that it is unconstitutional for the University of California to decide that the affirmative action program is no longer necessary?
No, it is another argument because they will eliminate their affirmative action, but here in our CCRI it is not permitted to have any preferential treatment. That might be the argument against the CCRI.
So it's not only that you're taking existing programs away, you're prospectively prohibiting them from coming into existence.
That's all.
Thank you.
Thank you. Good afternoon, Your Honor. My name is Esther Kayet. Me and my partner, Miguel Ramos, represent the respondents in this case. First of all, the respondents, some arguments from the parents. The petitioners has the burden to prove why the discriminate law is still necessary, and they didn't show it. And the society changed, but my partner will more about it. And the issue here is if alienated by the state of California suppressing privilege based on race and gender would violate the 14th Amendment, the right of equal protection. And the answer is no, because the suppression of preferential treatment is constitutional, as this court in Crawford and Board of Education of the City of Los Angeles has already stated. The court decided in Crawford not support that once a state chooses to do more than the 14th Amendment requires, it may never receive. Such an interpretation of that amendment would be destructive of the state's democratic process and of its ability to experiment in dealing with the problems of a heterogeneous population.
Counsel, I think Crawford is an important case here. It's only one of 3 cases that deal with this issue. The other 2 are Hunter versus Erickson and the Seattle School Board case. So help me to understand how these 3 cases fit together. Because the Seattle School Board case seems to say that it's unconstitutional to move affirmative action programs from local decision-making to a statewide level of decision-making. And that's what CCRI does.
The Washington case, the strongest argument was the political structure. In that case in Washington, the initiative affected a racial classification by removing the authority from existing decision-making in such a way a burden minority. But why burden? Because they are really in much smaller number than the white majority. In our case, the minority and the women, the beneficiaries of the law, are the majority. So, in this case, there's no allocation in our case of government power to a new and remote level of government. Because our beneficiaries are the new level of government while you're voting the Proposition 209.
So let me understand this argument. If CCRI only applied to African Americans, I know it doesn't. It applies to other ethnic minorities and to women and men as well. But suppose we had a narrower CCRI dealing exclusively with race, blacks and whites. Would you say that CCRI would be unconstitutional then because African Americans clearly are a minority in California?
CCRI is the Proposition 209.
Yes.
The population of the California, actually the last census shows that the white population is smaller than the other race.
Well, that's if you put all other races together, but I'm saying.
The other races, especially blacks and Hispanic population, who are the strongest beneficiaries of the preferential vote law.
So if racial minorities, former racial minorities, were still minorities in California, if they didn't make up the majority, would you think CCRI was unconstitutional?
Just to understand, Your Honor, my argument was that the last census shows that the white population is smaller.
I understand. I'm saying, suppose the numbers were different. Suppose we were in a different state, hypothetically, where African Americans and Latinos clearly did constitute a minority. In that circumstance, would a law like CCRI be unconstitutional?
In a hypothetical situation.
Hypothetical, yes.
Hypothetical situation, as was in the Washington, in Seattle, when the white population is much bigger than the black population in Washington, the population is 84% of the whole population. In that situation, okay, it's inconstitutional because the whole of the government is to balance the power between the majority and the minority. Okay, it's clear. But in our situation, it was not what happened. In this situation, all races had completely participation in the democratic process.
Time's up. I was going to ask another question, but time's up. Thank you, guys.
Good evening, Your Honor. My name is Miguel Ramos, and we represent the respondent. I would like to argue some effects that Proposition 209 brings to the state of California with benefits. For example, taking in mind the opportunity to study. In California, everybody has the same opportunity to have education. Early studies suggest that Asian American students were the major beneficiaries of Proposition 209. At UC Berkeley, for example, Asian American enrollment in college jumped from 37% in 1995 to 43% in 2000. We think that the maintenance of preferences based on race and gender reproduce a thinking of stereotypes. To pursue the concept of